Thank you, Christina, for your kind invitation, dear colleagues. I mentioned bubbles that might contain us in the morning. So all I can offer you is sharing some thoughts of a human rights lawyer on the interrelation between human rights law, HRL, and international criminal law, ICL. And in this regard, I will first address the historical background that paved the way for an unprecedented development in public international law, the horrors of the Second World War, and the atrocities committed in the first half of the 20th century. Admittedly, one might trace back the origins of ICL and HRL even to ancient times. However, their positivation and institutionalization on the superstate level have to be recognized as a quite recent development. Before 1945, neither HRL nor ICL actually could break through. And we know the German Emperor William II did not face trial and prosecution, even though the Versailles Treaty asking for it, nor was it possible to establish an effective human rights regime on the level of public international law, which remained mostly regulating interstate affairs and the coexistence of states. With the International Military Tribunal of Nuremberg, for the first time, the most prominent perpetrators of crimes committed against the international community as a whole have been charged and prosecuted. And as it is so nicely phrased, I'd like to quote the tribunal stating that there are no doubts that crimes against international law are committed by men, not by abstract entities. And only by punishing these individuals can international law be enforced. Quotation ended. While neither the IMT statute nor the Nuremberg Principles explicitly referred to human rights as a notion, they guaranteed fair trial. And it was Jackson reminding that, I quote again, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow." And he warned to pass these defendants a poisoned chalice. Thereby, even then, it was reflected that human rights of the accused persons play a crucial role. The modern human rights development started a little later with the Universal Declaration of Human Rights in 1948. And some argue that its adoption wouldn't have been possible without the Nuremberg trials. Anyhow, also, the declaration is a reaction to the Second World War, referring in its preamble to barbarous acts which have outraged the conscience of mankind. Thus, the development of HRL and ICL have been triggered by the same historical events, and one can say that international individual criminal responsibility, as well as human rights, are the lessons learned. In the further legal development, I dare say that HRL has somehow taken the lead, and actually it has been found by our keynote speaker that the political momentum leading to the establishment of the ICC can largely be attributed to the international human rights movement. On an abstract level, both branches of law contributed to the recognition of individual partial subjectivity under international law by either imposing duties or granting rights irrespective of domestic law. And this emancipation from a full mediatization by the respective home state indicates an understanding to which public international law, mostly confined to regulate interstate affairs, has proven to be insufficient to meet the challenges of a new era and questions of global nature. Furthermore, both branches of law can be seen as an emanation of universal values. The fight against impunity is not an end in itself, but as with human rights law, serves the idea of protecting human dignity and humanity. Thereby, human rights law and ICL appear as united drivers for a peaceful revolution in public international law, transforming it into a legal order that even more visible serves the interests of human beings, and thereby potentially moving in the direction of early thinkers such as Georges Seurat. Bearing in mind the common history as well as the similarities sketched so far, allow me to reflect on the interrelation between HRL and ICL on a normative level, starting with the transformation of human rights into the language of international criminal law. And without doubts, each of the 4 international core crimes has a human rights dimension. Already the crime of genocide is phrased exactly as the definition under the Genocide Convention, which entering into force in 1941 can be said to be the first human rights treaty. The main idea behind genocide is the destruction of a group, as already Raphael Lemkin argued. So consequently, the right to life, and there is a relation in Article 6 ICCPR to the Genocide Convention, interestingly, but also the right to integrity, to family, and not to forget collective identity and minority rights are violated by genocide. Their protection, however, is limited by the need of a genocidal intent and the attack to be ultimately directed at a certain real or imagined collective. Crimes against humanity are labeled the most obvious proof of ICL codifying and concretizing violations of human rights, and they cover actually a broad variety of rights, such as dignity, integrity, autonomy, but also protection from discrimination and protection of minority. This is particularly reflected by persecution, which is defined to generally cover, I quote again, the international and severe deprivation of fundamental rights. Also, war crimes sanction grave violation of human rights, reflecting a development of the law of war to international humanitarian law, from The Hague to Geneva, so to say, which puts more emphasis on ensuring humanity even when weapons speak. However, also crimes against humanity and war crimes fall short of a full human rights protection, as they are either confined by the nature of the violation or the conflict and the victims. War crimes, as we know, presuppose the special situation of an armed conflict. Crimes against humanity, in contrast, apply in peace times, however, require a widespread or systematic attack directed against the civilian population. They were also reflecting a collective dimension, so to say. Let me finally address the crime of aggression. It has been argued that its primary aim is not protecting individual rights, but to guarantee international peace and security. Well, from a human rights perspective, I would first respond that peace and security are fruitful for the enjoyment of human rights, even not a necessary requisite. Second, we see a development in HRL that enriches and complements the crime of aggression by the recognition of not only a collective, but also an individual right to peace, as the UN General Assembly has done in 2016. And third, another inherent human rights dimension of the crime of aggression can be detected in the threshold clause connected to humanitarian interventions. I know this topic is highly controversial, but under the threshold clause, one could argue that the unilateral use of force justified by humanitarian consideration at least does not amount to a manifest violation of the UN Charter and the prohibition of the use of force. Second aspect, to effectively sanction massive and serious human rights violation, ICL depends on interpretation. Its interrelation with HRL is also reflected by the cross-referring between courts and tribunals. First, and I would say unsurprisingly, criminal courts have stressed that human rights cannot themselves be the base for criminal responsibility. They also have stressed that they are not vested with function of human rights courts. However, Article 21, paragraph 3 of the Rome Statute builds a bridge, requiring that the application and interpretation by the ICC must be consistent with internationally recognized human rights. And indeed, we detect an intense and increasing referral to and adaptation of human rights jurisprudence in criminal proceedings. Just to mention a recent example, in February 21, in the Ongwen case, the trial chamber extensively cited jurisprudence of the European Court, the Inter-American Court, the African Commission, and also referred to the UN Human Rights Commission, the former Human Rights Commission. And furthermore, the chamber invoked several human rights treaties, but also reports, outcomes of conferences and documents, such as the Universal Declaration, which are not binding by themselves. Thereby, it additionally justified that torture does not necessarily require physical injury, that rape does not require resistance of the victim or physical force, that sexual slavery does not need physical contact, but might also be carried out through sexual means in general or by targeting sexuality. To ground forced pregnancy, for the first time addressed by the ICC, on the right to autonomy and to family, the chamber referred to treaty law and again, non-binding human rights documents. And with regard to fundamental rights protected by persecution, the chamber referred to the Universal Declaration altogether without delving into this question. To justify a conservative interpretation of the term inhuman acts, it resorted extensively to human rights jurisprudence, requiring consistency with the essence of the offense and reasonable foreseeability. And what I found very interesting, it not only referred to numerous human rights treaties, but also to the Islamic Declaration of Human Rights to prove consensus that marriage must be based on free and full consent. Interpretative interrelation is not a one-way street, though. In fact, though more rarely, have human rights courts also referred to criminal jurisprudence. So has, for instance, the European Court referred to the ICTY, justifying that domestic courts are entitled to jurisdiction and that this is not a violation of the Genocide Convention. And in a more recent judgment in 2016, it found under referring to the ICTY and the ICC that evidence obtained illegally, there was no access to a legal counsel, is not automatically excluded if the proceeding as a whole has been fair. To me, it does not seem unreasonable that human rights courts will more often refer to evolving criminal jurisprudence. This could help those human rights courts to subsume forced pregnancy, forced marriage, sexual slavery, or the forced witness of killing other peoples through or under mostly vague phrased norms of human rights, such as inhumane treatment. And also cases such as the Al-Mahdi case can strengthen human rights protection. The human rights to participate in cultural life and the protection of national cultural heritage. And that has been stressed in the reparations ordered by the ICC, but also recently in another policy paper of the prosecutor on cultural heritage protection under international criminal law. So also ICL can have a positive impact on the further development of human rights. Such dialogue of different courts can, on a more general level, contribute to overcome fragmentation and to forming a truly global consensus. By referring to different documents and case law from various legal and cultural traditions, so to say, to my understanding, one proceeding can actually become an intermediary forum for cross-border deliberation. After recognizing cross-fertilizations, time has come to address mutual limitations. Limitations by ICL on human rights mostly stem from the sanctions imposed. And it's interesting that the right to life remains unaffected, as death penalty is no longer an option. I mean, we know Article 6 ICCPR strives for the abolition of capital punishment, but so far, to the majority understanding, it does not stipulate an absolute ban. And that such an agreement could be reached for international criminal law has to be praised as a progressive achievement from a human rights perspective. So in the end, it's personal liberty that remains the right limited by a sentence to imprisonment. However, reaching a verdict of guilt also requires respect of fair trial standards and the rights of the accused. And so we see a twofold entanglement between HRL and ICL. While the protection of human rights constitutes one rationale behind ICL, with committing international core crimes justifying the deprivation of liberty, at the same time, human rights impose limitation on the use puniendi, be it international or domestic. We all know that the Rome Statute undoubtedly contains such guarantees, be it presumption of innocence, right to effective defense, examination of witness, you name it. And we will also address during this conference new challenges coming up, like electronic evidence. So I will confine myself to 3 arguments only. The first one being whole life sentence. The European Court has decided that life sentence does not per se amount to a violation of the convention, but that Article 3 requires its reducibility in the sense of a review procedure enabling authorities to probe rehabilitation. So the person must enjoy at least the expectation to be released in future. As the imposition of life sentence by the ICC is binding on the states, it will be difficult for those states designated to comply with this human rights jurisprudence. But again, we know there is a review of sentence procedure provided for in the Rome Statute. However, the aspect of resocialization is mentioned only in Rule 223 as one criterion that shall be taken into account. It is not mentioned explicitly in the Charter directly, which focuses more on the cooperation of the finally convicted with the court. And so one may raise doubts whether actually the crucial relevance of rehabilitation under human rights law is adequately safeguarded in the Rome Statute. My second concern refers to trial in absentia. To exercise his rights, the accused has to be present at trial. At least he has a right to be present. And trials in absentia are not entirely prohibited by human rights. They require, though, a knowing, intelligent, and explicit waiver of the right to be present, and if not, the right to fresh determination of the merits. The Ayash case before the Lebanon Tribunal was entirely held in absentia, therefore raising severe human rights doubts. In contrast, Article 63 of the Rome Statute says the accused shall be present during trial. And that has initially mostly been interpreted as a strict rule. But on proposal of African states in 2013, the rules of the courts have been amended to ease somehow trials in absentia. So far, the ICC and the prosecutor have taken a very reluctant perspective on this question, confining trials in absentia to exceptional cases. However, in the recent Gbagbo decision, the appeals chamber assumed to be permitted to hold trial of an accused who is willfully absent, who has implicitly waived his right to be present or absconded. That should be in line, or was claimed to be in line, with general principle in human rights. However, doubts have been raised. First, whether notification is sufficient to actually assume an informed waiver when it comes to the date, the time, and the location of the trial. Furthermore, an implicit waiver of the right to be present is not foreseen by the statute and the rules of the court. In that case, to uphold standards foreseen in procedural law, even if they are stricter, is a human rights obligation and an expression of fair trial. My last concern is based on a broader consideration of the ability of ICL to adapt evolutionary interpretation of human rights. We currently face many strategic litigations to protect the environment and fight climate change. Some of them already have been successful. And environmental protection has been deduced from the existing human rights standards. Besides the right to safe, clean, healthy, and sustainable environment, which was already part of third generation rights and has last week been recognized by the Human Rights Council of the United Nations to also be an individual right. Likewise, the claim for ecocide to become a distinct international core crime has gained new momentum with a draft definition proposed, I think it was last June. I assume that the statute is not very likely to be amended. But I read yesterday in the newspaper that an Austrian NGO is asking the prosecutor to initiate investigations against Bolsonaro and his deforestation policy. So the question is, what can we do with existing international criminal law? We know degradation of the environment can, under certain circumstances, amount to a war crime. But what about crimes against humanity? Also protecting the right to health and the right to life. Wouldn't it be possible to find environmental degradation to be a violation of these rights, as other courts have done before? Ladies and gentlemen, I have severe doubts based on the nullum crine sine lege previa certa et stricta principle. Criminal courts ought to show reluctance with regard to legal certainty. It must be predictable under which condition a person commits a crime. And in this respect, it has inter alia to be stressed that the emission of greenhouse gases so far is not a crime. Companies also having licenses to emit these greenhouse gases. And furthermore, the causal nexus between harm to legal interest and individuals' contributions to climate change is difficult to determine. And furthermore, it will also be difficult to provide a widespread systematic attack against a civilian population, because the population must be the primary target of the attack and not an incidental victim. So even if it sounds paradoxical, from the human rights perspective, criminal courts are asked not to be too hasty in adapting developments in human rights. Let me finally touch upon the interrelation with regard to enforcement. We heard about it in the morning. The prosecution of international crimes also serve the interest of human rights protections. And we know that human rights treaties provide for an obligation to enact, to prosecute people alleged offenders of international crimes, but also contain an obligation to extradite. And combined with universal jurisdiction, that can contribute to effectively fighting impunity. And also mentioned in the morning, should the ILC draft articles, the draft convention on crime against humanity, actually become law, there would be an additional type for this, an additional basis for this type of cooperation. But states are showing some reluctance with regard to accepting jurisdiction of international courts. So one question might be, could general human rights law step in? And as Shabazz mentioned in the morning, courts have already deduced from general human rights law an obligation to enact and enforce criminal law. If we additionally bear in mind the claim for universality by human rights, as well as the recognized principle, I dare saying, of a responsibility to protect, couldn't that amount to a general human rights-based obligation to ratify the Rome Statute, or at least to make universal jurisdiction a norm under domestic law? Unfortunately, I feel obliged to say no so far from my perspective, particularly as human rights cannot totally override the principle of sovereignty and the emanation of the principle of consent. And second, we have to recognize that still the territorial scope of human rights is a narrow one, even under the jurisprudence of the European Court. So that states become the forum for the entire world, to me currently seems not to be deducible from general human rights, but you never know in which direction, for instance, the European Court or the Intermediate Court will move. So in the opposite direction, we see attempts to use international crimes to compensate lacuna in human rights law. For instance, missing supply chain responsibility of corporations. And criminal charges have recently been filed in Germany and in France. Or a second example, if the crime of aggression actually becomes operational law, the ICC could indirectly remedy victims that hardly have a human rights courts to address. And finally, my last point, we see a multi-track approach. Georgia, as well as Ukraine versus Russia, are examples in which a highly political conflict has been brought before different courts. The ICJ, initially dismissing Georgia's case, has accepted jurisdiction in Ukraine's proceedings against Russia, inter alia on the basis of ICERT, another human rights treaty, which could be used to challenge Russian patterns of conduct in Crimea towards minorities living there. Before the European Court, Georgia was successful, as this court in January this year determined several violations of rights under the convention attributable to Russia. And the court also recently declared an interstate proceeding of Ukraine versus Russia partly admissible and will be able to decide upon the merits, already having stated that there is sufficient prima facie evidence for an administrative practice of human rights violations. And finally, regarding the ICC, already 2016, pre-trial chamber authorized an investigation into the situation of Georgia. And furthermore, after a preliminary examination of the situation in Ukraine, the prosecutor will now request authorization to open a formal investigation against Russia. So human rights, ICL law in their respective courts can contribute to address such situations from various legal angles in sense of a compressive and comprehensive assessment and potentially be part of a solution. However, at the same time, the leverage of ICL and human rights law is limited. Neither of them is adequate to solve the big political problems that remain mostly in the realm of general public international law. That is shown by the Lebanon Tribunal not meeting the expectations initially justifying jurisdiction over terrorism. And it is also shown by the cases mentioned with regard to Russia, as all the courts have acknowledged the lack of competence to decide upon the root causes, and that is the prohibition of the use of force and the admission of Crimea into Russia. So let me conclude. I dare saying that HRL and ICL are relatives, but they are not twins and potentially not even siblings. It is important not to equate these branches of law. ICL is having a distinct functional logic. It serves interests that they even transcend the protection of human rights, and it's providing for a comprehensive regulation of competencies, procedures, and sanctions. In Target, it has been claimed to be a self-contained system. In contrast, HRL is characterized by its cross-sectional claim to universal validity and application. And for this reason, HRL is having such a strong impact on ICL. From the perspective of a human rights lawyer, ICL plays a crucial, though subsidiary and complementary role for the protection of human rights based on the idea of general prevention. But even though we face a process of harmonization, we should not overestimate the relevance of ICL for human rights protection, because first, there will never be full harmonization and the overlap will always remain limited. And second, human rights law is not confined to repressive sanction, but also based on different approaches to respect, protect, and fulfill human rights and those human rights that are not covered by international criminal law. So it can be said that while human rights law strives for the establishment of a good society, international criminal law addresses exceptional cases, states of emergency, the disruption of a regular order. But as both branches of law are facing severe opposition and challenges on the international level, the human rights perspective on international law before domestic course is of utmost importance. And so I can finally only hope that this conference will be a modest contribution to strengthening ICL. Thank you very much.
enslavement, of persecution, of torture, and even of killing, like the case of Jennifer W., what is still going on in Munich. The verdict will be handed down later on this year, maybe in October or November. Most prominent case at the moment in the cumulative prosecution is the case of Taha Al-Jay, the husband of Jennifer W. What is going on in Frankfurt at the moment because of the killing of a Yazidi child as a war crime and a crime of humanity. And that's most important, and as an act of genocide. This is the first time that an ISIL fighter is in court in trial because of genocide against the Yazidi community. This judgment will be delivered in November, probably. So, in fact, the cumulative prosecution are the standard charges for ISIL-related suspects now. It's not only for ISIL members, but even for other non-state actors. The cumulative prosecution, from our point of view, fulfills the requirements of ensuring the full criminal responsibility. Yeah? It shows the full picture. Charges of membership in an organization, terrorist one or whatever, is a quite abstract, art charges. If you want to deliver justice, especially to the victims of mass atrocities, you need to name the crimes for what they are, and not just this abstract membership thing. With this, I quoted the fundamental report on cumulative prosecution edited by the Genocide Network Secretariat. Matthias is with us to promote this legal tool. I strongly recommend this. This is public and can be read on the website. Am I right, Matthias? European countries like the Netherlands, Hungary, Sweden, France, and Finland developed jurisprudence on this, and international organizations like the UN entities IIIM and UNITAD provide assistance and evidence to national prosecution and courts. And I'm deeply convinced that the strategy of cumulative prosecution is an appropriate answer to mass atrocities committed against civilians and persons protected under international humanitarian law by organized non-state actors. Well, international crimes as a result are described in the Rome Statute, as described in the Rome Statute, are, at least from my point of view, terror to the utmost. They are terror to the utmost. Why should we not punish them like this? Thank you.
Many thanks again for yet another excellent presentation. Well, we already have questions on the chat, but I would nevertheless start perhaps with the persons here in present. First question behind.
Hello, my name is Serhii Masol. I'm currently affiliated with the Institute for Human Sciences, Institute für die Wissenschaften von Menschen here in Vienna. I have a question to the first speaker, Professor Fremuth. I wonder about the institutional dimension of the problem. Which of the international tribunals, whether current or former, is the most open or has been the most open to borrowing human rights concepts, norms, human rights interpretive doctrines based on their divergent legal frameworks and jurisprudence? Thank you.
Yeah, I would say we collect 2 or 3 questions. Actually, I was given permission to go a little bit over time, but nevertheless, we have to keep, so this leaves us around perhaps 15 to maximum 20 minutes, but let's collect. Professor Balthasar.
Does it work? Fine.
Yes.
Question added to the second speaker. You mentioned that one of the elements of the terrorism definition in your national crime code is murder. I'm interested in elements of justification, whether you take them into account. Against the background that you first said that acts of killing, also targeted killing, for example, committed by state authorities are not taken into account because there is state immunity. Of the opposite side, we have the fundamental right of resistance against tyranny and oppression, for example, enshrined in Article 2 of the famous French Declaration of 1789. So what is it really the task, I would add, of the German courts to take part in the assessment of internal political conflicts of other states with regard to their quite perhaps complex history, in particular when only the less successful side can be prosecuted in Germany. I would give an example. Now, after the successful taking over of the Taliban in Afghanistan, is it really a realistic option that a successful attack of an Afghan resistance group with regard to a member of the new Taliban regime will be prosecuted in Germany?
Many thanks. Perhaps I take another question from the chat where questions are coming in to Professor Fremuth. Would you please expand on the legal basis of your suggestion that humanitarian intervention would not be an